Okay, good evening, everybody. It's a real pleasure to welcome you all tonight to CCPL seminar on recent developments in judicial review in the common law world. It is an even greater honor to introduce to you all Professor Christopher Forsyth, who of course is no stranger to any of you and not to Hong Kong either, given that he's been here before on numerous occasions to speak with various members of our legal community, including the civil service, and today, in fact, he's just come up from downtown having spoken to members of the Department of Justice. Professor Forsyth is a professor of public law and private international law at the University of Cambridge. He is also the author of numerous books, but most well known perhaps to many of us as the author of Administrative Law, which is an authoritative text relied on by many around the common law world. He also is a sitting judge and a bencher of the Inner Temple, a recorder of the Crown Court, and is authorized to sit in the Administrative Court as a Deputy High Court Judge. So Professor Forsyth today will share with us recent developments in judicial review in the common law world, which many of us would appreciate here in Hong Kong. Is of a great deal of interest given our own sort of flurry of judicial review cases that have been coming through our own courts today. So please join me in welcoming Professor Forsyth.
Thank you very much, Pooja, and thank you very much for that. I'm here slightly under false colours. When I described the title of the talk as Recent Developments in Judicial Review, they're recent developments that are going to appear in Forsyth, and that book comes out. I've just finished. I've been spending the last year writing the new edition, the 11th edition of the book, and it will be coming out in the middle of this year. And what you're getting this evening is a foretaste of some of the highlights, some of the outrageous views that may be in that new edition. And the first one that I want to talk about is the survival of Wednesbury. Now, we all know the basics of Wednesbury, and I've set out on the handout the famous quotation from Lord Green in Associated Provincial Picture Houses against Wednesbury, where he says, similarly, there may be something so absurd that no sensible person could ever dream that it lay within the powers of the authority, setting the standard of absurdity or gross unreasonableness so unreasonable that no reasonable decision-maker could reach it, the various other ways in which this principle has been articulated, that we have come to know as Wednesbury unreasonableness. Now, Wednesbury has been much criticised as a test of substantive review for many years. The grounds of criticism have been primarily that it is too deferential to the decision maker, on the one hand, and secondly, that it isn't transparent. One person's absurdity is not another person's absurdity, and it is just announced. In other words, the judge decides as a gut feeling that this is now too absurd or too unreasonable. For that reason it is bad. In fact, that has been, and this isn't in the handouts, anybody paying too close attention won't find this in the handout. Lord Carnworth said in an Administrative Law Bar Association lecture just a couple of months ago, he said he's never applied the Wednesbury test as it appears in the textbooks, to ask whether it's so absurd that no reasonable decision maker could have reached it, anything like that. He says he looks at the decision and decides whether he thinks there's something wrong with it. And if there's something wrong with it, he looks for a legal hook on which to hang that result, which is honesty in a judge, but disconcerting nonetheless, because it makes so much of what we jurors do, whether in arguing cases, whether in writing about cases, whether in teaching about cases. It makes it so much redundant if what it really depends upon is the judge's gut feeling, and he then finds the appropriate hook on which to have it. So Wednesbury has been much criticised as being too deferential and not sufficiently transparent. So unsurprisingly, because of that criticism, when proportionality first unequivocally was introduced into English law with the Human Rights Act of 1998, there was much enthusiasm for proportionality as a substitute for Wednesbury. Proportionality was, or was at least perceived to be, less deferential, and with the structure test of proportionality, which I'm not going to go into in detail this evening unless anyone wants me to, the structure test of proportionality more transparent than Wednesbury. Some of that support for the idea that Wednesbury would be overwhelmed by proportionality comes from some very important sources. Lord Cook in Daly said, "The day will come when it will be more widely recognised that Wednesbury was an unfortunately retrogressive decision in English administrative law." You can decide it in there. The Court of Appeal in the Absifer case said that the Wednesbury test is moving closer to proportionality, but it's not for this court to perform the burial rites. So it was generally assumed, looking at those cases, that the direction of travel was going to lead to Wednesbury being subsumed in proportionality, and indeed many important authors and cases seem to suggest that would be the case. And the crucial point to make is that it hasn't happened. More recent cases tell a different story. And we've got to say a little bit about the cases before one can see the point. Perhaps the most important case is the decision of the House of Lords, one of its last decisions, a case called Ahmad in the London Borough of Newnham, which is about housing policy. And as many in the room will know, but some may not, in the United Kingdom, local authorities are often landlords for tenants, council tenants, tenants of the local council, who benefit from subsidised rents. Now, there are many more people who would like to rent council accommodation than there is council accommodation for them to rent. And many of the people are in much more acute need than others, sides of their family, particular needs of particular members of the family and the like. And so every local council has to have some kind of policy for allocating the houses that are available for rent to the tenants who are in need of places to rent. But there always has been, I think this is probably a reflection of the fact that the rents are subsidised, there always has been a far greater demand for council tenancies than there has been a supply. Now, what happens when a judicial review applicant wishes to challenge a local authority's housing allocation policy? This has generally been done on the basis that the housing policy operates unfairly in respect of persons in their situation. What is the court's attitude? Does it adopt a more intensive scrutiny, which we might call proportionality, or does it say Wednesbury is the appropriate standard? And in the Ahmed case, where there was just such a challenge to the housing allocation policy of the local authority, the court, having found that the scheme, the particular local authority allocation scheme, having found that the scheme was not in breach of any of the relevant statutes, went on to say the court is in no position to rewrite the whole policy and to weigh the claims of the multitude who are not before the court against the claims of the few who are. Once a housing allocation scheme complies with the statutory requirements, the courts would be very slow to interfere on the grounds of alleged irrationality, irrationality being often used as a synonym for Wednesbury unreasonableness. Proportionality is not mentioned in any of the speeches of the House of Lords, and the analysis is classic Wednesbury. These examples could be multiplied. One of the other cases which one might mention is the Supreme Court's first case it ever decided in the governing body of the JFS case, in which it was a question of challenging a decision of the Legal Services Commission to refuse funding in particular circumstances. The Supreme Court's first case didn't mention proportionality, classic Wednesbury analysis of the substantive judicial review, and in fact a finding that in the circumstances it was Wednesbury unreasonable to refuse legal aid in those circumstances. The reasons for the survival of Wednesbury are not hard to find. The more you think about the structured test of proportionality, the more it becomes clear that it is not really designed to deal with all kinds of dispute, notwithstanding suggestions that that is exactly the role that it could play. Where rights are specifically protected in law, then the court's task is to protect those rights. But that's not a straightforward task. And the reason for this is in that in a modern liberal society, we are not arguing about the fundamental principle of whether a right should be protected, whether there should be freedom of speech. We are arguing about the limitations of that right. And in the United Kingdom, this is particularly obvious because of the structure of the European Convention. Hardly anybody else stands up in courts. In fact, one couldn't because the law was so clear and saying there shouldn't be a right to freedom of expression. Everyone will stand up in court and say there's a right to freedom of expression, but in this case it is lawfully limited, or the limitation imposed upon it in this case is not justified. And proportionality fits into that scheme. Proportionality is part of the culture of justification, that a fundamental right is protected in law, that it is liable to be limited, but of course it can only be limited if the limitation is justifiable, is justified. And proportionality is the means used to determine whether it is justified. So you ask the classic proportionality questions, which I set out in the handout in note 1, whether the legislative objective is sufficiently important to justify limiting a fundamental right, whether the measures designed to meet the legislative objective are rationally connected to it, whether the means used to impair the right of freedom are no more than is necessary to accomplish the objective, whether a fair balance has been struck between the rights of the individual and the interests of the community. Those are the 4 tests of the proportionality test. But you can immediately see that that works for rights. That works for rights as a way in which you decide whether a limitation on the right is justified. It doesn't work for the much more diffuse, polycentric kind of dispute. The court lacks the expertise and the legitimacy to assess those other kinds of disputes. The contending policy considerations which underlie the substance of the discretion in the absence of fundamental rights being protected are much more diffuse or polycentric. Thus, in the housing allocation scheme case, there was a strong demand for housing, far in excess of supply, but no one had any legal right to a tenancy. No one had any legal right to the tenancy, and prospective tenants had needs of different intensity. Whatever allocation scheme might be adopted, there were going to be unhappy prospective tenants. While the courts might usefully scrutinize the scheme for perversity, improper purposes, and irrelevant considerations, there was not much else they might constructively do. Certainly they cannot conjure extra housing out of more intense scrutiny. Allocation of scarce resources, in other words, must be a matter for the public authority, not the courts, save in exceptional circumstances. The consequence of that, of course, is that the test of substantive review becomes the more deferential Wednesbury rather than the more intrusive proportionality. But if there are functional reasons for the survival of Wednesbury, there are conceptual reasons too. Wednesbury and proportionality have different starting points and different structures. With proportionality, the impunged decision is prima facie an infringement of a protected right, and so prima facie beyond power. The right is specifically protected. Here is a limitation on the right. It's prima facie beyond power and needs to be justified. So it falls to the public authority to provide that justification by passing the proportionality test. But with Wednesbury, it's the other way round. The decision impunged is apparently within power. It's fine, except for the fact that it's absurd. It's apparently within power of the decision maker, and it's for the claimant to show that, in fact, it's perverse. These two tests, in other words, have different starting points, different purposes, and are not easily merged. So that's why it seems to me in the United Kingdom we have the situation where it's generally recognized that the Wednesbury test has survived and is unlikely to disappear soon. As far as rights are concerned, proportionality comes into its own there. But as far as straightforward classical administrative law decisions are concerned, Wednesbury still seems to hold sway. That is perhaps an opinion or conclusion that should be qualified somewhat. First of all, because there's a very recent case from Australia called Minister for Immigration and Citizenship against Lee from the High Court of Australia, where Chief Justice French said a disproportionate exercise of an administrative discretion taking a sledgehammer to crack a nut may be characterized as irrational and also unreasonable, simply on the basis that it exceeds what in any view is necessary for the purpose that it serves. So he is tending to assimilate proportionality and unreasonableness. But of course, in Australia, he is doing that in the context where you do not have the protection of fundamental rights, so the classic proportionality question does not arise. I might also mention, going off script again, that it's quite intriguing in Hong Kong to look at the Kong Yung Ming case. This is the case about social welfare, social welfare law, which is protected under Article 36 of the Basic Law, where the Court of Final Appeal said that the appropriate test was to uphold the existing law, save where it was manifestly unreasonable. I think they might have said wholly or manifestly unreasonable. I have the phrase slightly wrong. But it suggests a much more deferential Wednesbury-type standard was adopted in the context of social welfare rights protected under Article 36 of the Basic Law. So that is quite intriguing. What is even more intriguing about that decision is that when judges say things such as the appropriate test in this case is that it has to be shown to be wholly unreasonable, wholly without reasonable foundation, you always anticipate that the judge is moving in the direction of saying, and of course in this case that height standard is not satisfied, and so the applicant is going to lose. But in the Social Security case, in the Court of Final Appeal, they set this very high standard, but I've got the phraseology slightly wrong, that it was some wholly unreasonable foundation, words to that effect. They came to the conclusion that it was on a wholly unreasonable foundation. That was a bit a surprise. So there we have. Wednesbury in the United Kingdom is surviving. These other suggestions from elsewhere, well, not from Hong Kong, but maybe taking the role of proportionality in social welfare law at any rate, in Hong Kong, and perhaps being all mixed up together in Australia. But Australia, because it has no fundamental rights protection in their constitution, but does it actually need proportionality? So that's one, not particularly radical, but interesting idea to think about the survival of Wednesbury. Here's a more difficult and I think likely to prove more controversial point of view about proportionality, the inevitability of incommensurability and the consequences for deference. the essential point that I want to make here is that the test of proportionality, in the end, requires the judge to weigh apples against pears. And if that's right, it then means that the outcome of the proportionality exercise depends ultimately upon a judicial gut feeling. If it depends on that judicial gut feeling, then it is not transparent, at any rate not transparent, as transparency is sold as one of the chief benefits of the proportionality test. I'm not going to argue that that means we can abandon proportionality, because as a matter of law, I consider that in the United Kingdom to be impossible, absent some profound change of heart in Parliament. But I think it does make the case for that other controversial doctrine of deference. The point is best made by a consideration of the leading case of Wheeler in the Supreme Court. The case concerned a change made to the immigration laws, in particular Rule 277. Now this rule concerned the circumstances in which an intending couple could, one of whom was entitled to remain in the United Kingdom, had leave to remain in the United Kingdom, and the other one that didn't. Rule 277 concerned how the one who didn't have leave to apply to go into the United Kingdom, to join their beloved and to marry them, or enter into a civil partnership, or whatever with their beloved, how that person could obtain that leave. And the change that had been introduced in the change to the Rule 277 was to say that although in the past it had been possible for any person over 18 to apply to bring their intended spouse, and I'm going to say intended spouse rather than intended partners, civil partners, etc. That would mean intended spouse, and that will accomplish them all. A person settled in the United Kingdom could bring their intended spouse in to join them to marry in the United Kingdom. They had both to be over 18 years of age. The change was to say that they had both to be over 21 years of age. In other words, they had now to be 3 years older before they could come into the United Kingdom and marry and live together in the United Kingdom. Why had the Home Secretary made this change to the immigration rule? She'd made the change because she was concerned about forced marriages. Now, forced marriages is a serious problem, the precise size of which nobody knows because it's kept secret. But the essential idea is that one person, usually a girl, quite a young girl, is forced against her will into marriage with a man. It's not arranged, this is not arranged marriage by the families, but it's forced marriage against her will. She's forced into a relationship with usually another man. The purpose being, one of the purposes of her being forced by her family into this relationship is in order that the man can acquire the right to enter the United Kingdom. And frequently also money changes hands in order to ensure that this happens. So it is a horrible occurrence and a complete denial of autonomy and a profound infraction of the human rights of what I will now call the victim of forced marriage. And the Home Secretary judged that by putting the age up to 21, the potential victims of the forced marriages would be 3 years older and therefore be older, more mature, and more able to resist the family pressures that were forcing her into the unwanted relationship. And that therefore this change in the rules would deter forced marriages. Of course, this created a great inconvenience for the many people who were perfectly innocent, and no one's ever suggested they were guilty, but it's quite convenient to say they're perfectly innocent. Couples who just wanted to get married and who found it very inconvenient to have to wait 3 years if they wanted to marry in the United Kingdom, or to live abroad for those 3 years somewhere else, because they couldn't get into the United Kingdom to marry. I may say, if you'll forgive me, if you're 18 and you really feel you need to get married, you're probably making a mistake. But one recognizes that this must have been quite inconvenient for these people, of which there were significant numbers. Now, how do we apply the proportionality test to this state of affairs? Well, let's see what the judges said. The crucial question was that the innocent persons were denied the opportunity to make an application for entry clearance, which is what the leave is called, until they were 21. And this was an interference with their respect for family life, protected under Article 8.1. And so the question was whether that was justified, whether it was a disproportionate or proportionate interference with their fundamental rights. The majority of the Supreme Court declined to accord a very substantial area of discretionary judgment to the Home Secretary's decision, and went on to conclude that her evidence that changing the rule would deter forced marriages was not robust. Moreover, there were very much larger numbers of bona fide advocacies who would be forced into exile or part by Rule 277. Thus, the majority concluded Rule 277 is a sledgehammer, that the Home Secretary has not attempted to identify the size of the nut. At any event, she fails to establish that the interference with the rights of the respondents under Article 8 is justified. It seems plain that the majority, and I think this is a relatively general problem in this area, that the majority was more sensitive to the rights of the people actually before the court than the ones who were not before the court. And perhaps there's a measure of that that is inevitable. But at its best, the judicial process will be sensitive, at least as sensitive to the rights of those people not before the court than those who are before the court. And bear in mind, in the Ahmed case, where, let me just lay my hands on it, where they said, the court is in no position to rewrite the whole policy and to weigh the claims of the multitude who are not before the court against the claims of the few that are. They recognized it there, that yes, here was someone before the court saying, I desperately want a tenancy, and I have a real need of a tenancy. And the judges think, well, we'll try and give them a tenancy, or maybe tempted to try and give them a tenancy. And to do that, of course, to allocate a tenancy to this person, makes it less likely that this one and this one and this one over there are going to get tenancies themselves. So it has a profound effect on the rights of, or the interests of those individuals. And you've got to be sensitive to that. And perhaps it's fair criticism of Quila to say that the judges were of course sensitive to the rights of the innocent other persons, the young people who wished to marry, the Romeo and Juliet before the court, rather than the victims of the forced marriages who were not before the court. Lord Brown, however, dissented sharply, and he said the extent to which the rule will help combat forced marriage, and the countervailing extent to which it will disrupt the lives of innocent couples adversely affected by it, is largely a matter of judgment. Unless demonstrably wrong, that this judgment should be rather for the government than for the courts. Still more obviously, the comparison between the enormity of suffering within forced marriages on the one hand, and the disruption to innocent couples within the 18 to 21 age group who desire to live together in this country is temporarily thwarted by the rule change, is essentially one for elected politicians, not for judges. It appears at first sight from those two passages in the judgments that I've read to you that the majority and the minority simply take different views over the degree of deference to accord to the Home Secretary's decision to change the rule. And that is just a reflection of the unpredictability of the whole process of applying the structured proportionality test. But Lord Brown points to a more subtle difference. He says, Lady Hale, I think you may guess that Lord Brown and Lady Hale do not get on particularly. He says, Lady Hale suggests that the right to marry is just as important as the right not to marry. But she cannot possibly mean by this that the postponement by up to 3 years of a couple's wish to live together as man and wife in this country involves just as great a violation of human rights as a forced marriage. What value then is to be attached to preventing a single forced marriage? What cost should each disappointed couple be regarded as paying? Really, these questions are questions of policy and should be for the government rather than us. You see, the point that he's making there is that one is weighing different things against each other. What one is purportedly doing is applying that third limb of the structured proportionality test, whether the infringement of the right is necessary. You supposedly applying that, and in some analyses you may be applying the fourth limb. I don't think anything turns on that. What you are doing is weighing incommensurable things against each other. Gross human rights abuse, small number of people, larger number of people, minor human rights abuse. Who can say where that balance falls? Is it for the judges or is it for the politicians? My argument is that that is a gut feeling. That is a gut feeling. The judge, obviously Lord Brown's gut told him one way, Lady Hale's gut told her another way, but it is a question of judgment. And the question is, who is the legitimate person to make that judgment? And it seems to me that striking that balance, particularly when it comprises judgments about whether the rule change is likely to deter forced marriages, is not an obvious judicial task. There is no calculus to meet the depths of human suffering, and no scale fine enough to weigh one human rights infringement against another. Judicial decisions presuppose a precision that is foreign to the imperfect muddle that is inevitable in these circumstances. Now, this is a general difficulty. I've shown it with the Quila case, and I think the Quila case is a good illustration of it. I've shown it with the Quila case. But it arises in many other situations in applying the test of proportionality, that you have to weigh an infringement of a right against some other public benefit, sometimes involving rights, sometimes not involving rights. So it is something that is inherent within the test. And the conclusion that I reach on that is that there is a case to be made, a strong case to be made, for a relatively substantial measure of deference in these circumstances. because the effect of deference in these circumstances, having carried out the proportionality test, is to leave many decisions in the hands of the public authority, which is where, it seems to me, on this analysis, probably. So I go on to the next topic. That might have been too exciting. Proportionality. But let's talk about something else. Another subject close to my heart, but is moving in the right direction. Can one have a legitimate expectation that a policy will be applied if one does not know about the existence of the policy? Take the case of Rashid in the Court of Appeal. This is not a recent case, it's about 8 or 9 years old now, but it illustrates the point. Rashid is an Iraqi Kurd who applies for political asylum in the United Kingdom, and his application is turned down. It's turned down on the basis that he's an Iraqi Kurd, and if he was sent back to Baghdad, he might very well be subject to persecution and therefore have a well-founded claim for political asylum. But in fact, it is possible for him to be sent back to the Kurdish autonomous zone of Iraq, where he will not be persecuted. And therefore, that is what he should do in his application for asylum, is turned down. He, of course, isn't happy with this, goes to see his lawyers. And his lawyers, I think this was only discovered between the first instance decision and the Court of Appeal, but his lawyers are diligent and fish out all the relevant materials and discover that, in fact, there's a Home Office policy to the effect that the Home Office will not rely upon internal relocation to defeat the claims for political asylum of Iraqi Kurds. Why is this? Because the government of the Iraqi autonomous zone had approached the British government and said, we're finding it terribly difficult, there are far too many of these people, we can't look after them, will you please stop sending them back? And the British government said yes. And then the Home Secretary proceeded to forget about that policy. Not the Home Secretary personally, but the immigration officers that had to implement the policy had completely forgotten about the policy, and so did not apply the policy in the case of Rashid. Now, one senses that Rashid may well have a good case here, but on what basis does he have a good case? Well, the Court of Appeal said he has a legitimate expectation that this policy will be applied. And all we're going to do is to protect his legitimate expectation. And of course the Home Secretary's Council said that he can't have a legitimate expectation. He never knew about the policy. It was only discovered by his lawyers shortly before the case in the Court of Appeal. How can he have a legitimate expectation that the policy would be applied? But the Court of Appeal said it would be grossly unfair if the court's ability to intervene depended at all upon whether the particular claimant had or had not heard of the policy. So Rashid's claim based on legitimate expectations succeeded, and his refusal of political asylum was quashed. That has always struck me as a fundamentally unsatisfactory state of affairs. Not that I don't think Rashid had a case, but because it so undermines what legitimate expectations are about. Legitimate expectations are about the protection of trust in the promises of government. That's why they're important. If the citizen cannot believe what he is told by the official, then government becomes a choice between chaos and coercion. There's no middle way, no way of order, where the official says, this is the way we're going to do it. The citizen thinks, well, that seems quite fair and reasonable. And then the citizen goes ahead on that basis and discovers that it's been done on a completely different basis. That citizen feels misled, very cross, their trust has been betrayed, and they're less likely to believe what officials say in the future. Legitimate expectations should be protected because one needs to protect the trust that individuals place in the promises of officials. But if that's right, it can't possibly be the case, can it? That if you don't know about the promise, the particular policy that you're not going to be sent, that internal relocation is not going to be deployed against you, you don't know about that. So you can't possibly have reposed trust in it. And so there's no legitimate expectation. That's a perfectly logical argument, but it's subject to a certain weakness, which is, suppose you had two Iraqi Kurds, one of which spent every spare moment trawling through the Home Office's website and knew about the policy, and the other one who was more laid back and didn't know about the policy. Otherwise, they're exactly the same. It seems wrong that the one should be protected and the other one should not. And that's really what's at the back of the Court of Appeal saying one doesn't need to have knowledge. But the real point here is that policy has to be consistently applied. There is a principle, and you can trace it back into some quite ancient cases, that policies, if you have a policy, you have to apply it consistently. You don't have to apply it if you've got a good reason not to apply it, but if you haven't got a good reason, you must apply it. And that is the principle that the Home Office breached in the Rashid case. Having a policy about internal relocation, they failed to apply it, and forgetting about it is not a good reason for not applying it. And that's the criticism that has been launched by myself and by Dr. Mark Elliott, reads his blog. That is the criticism that has been launched by Dr. Mark Elliott and myself against the Rashid case. But the real issue here is consistency in the application of policy. And I'm pleased to say in the case of Lumber and Mighty, the Supreme Court has accepted that. Lumber and Mighty is a case about foreign national prisoners. Foreign nationals who come to the United Kingdom, commit serious crimes, are sent to prison, and are then due to be deported at the end of their sentence. And they get to the end of their sentence, and the deportation decision is still being fought over. And the question is whether they should be held in immigration detention, or whether they should be allowed to be free in the community while the decision on their deportation is taken. In Lumber and Mighty, it transpired that the Home Office had had a published policy in which it said that generally people would be, generally foreign national prisoners would be released, save in exceptional circumstances, while the deportation decision was taken. That was their published policy, and they had an unpublished policy for a period of time, a secret policy, that they wouldn't let them out save in exceptional circumstances. In other words, the secret policy was the complete opposite of the published policy. And the Supreme Court said, policy must be consistently applied. And if you've got your published policy, you've got to apply it consistently. You can't have a secret policy. and they won. The interesting question is that Lord Dyson's judgment in Lumber and Mike turns entirely upon the consistency of policy, and legitimate expectations are not mentioned at all, although they were much argued in the case. The dissenting judgment of Lord Phillips is full of guff about legitimate expectations, mostly misunderstood, which you can look at and you can see that the concept added absolutely nothing to understanding of the issue. And so I'm quite pleased that that development is moving in the right direction. And knowledge will be required to have a legitimate expectation, and policies will have to be consistently applied. Yes, you have a question. Now, let's ask the questions.
Thank you, Professor Forsyth, for sharing with us some of these developments. Professor Forsyth is very happy to take questions from the floor, so I'd like to open it up here.
Hi, I'm Shafan, a legal barrister in Hong Kong. You mentioned that when it comes to proportionality, the courts should be more deferential to policymakers in terms of weighing up different rights. Is there anything that possible that could happen that might change your mind?
I hope I always change my mind when I get the evidence that suggests my previous view was right, or was wrong. So yes, of course, I would change my mind if I am persuaded that it's wrong.
I mean, in terms of anything the government could do, that would make you think that the balance should be different in terms of deference.
Let me put it this way. There is a tension, almost a conflict, in all constitutional orders between the judiciary and the executive, and between the judiciary and the legislature. They jostle for power. And what we've actually been talking about in the test of proportionality and indeed in Wednesbury is really how that power should be distributed, allocated between those different branches. The real answer to that question depends upon the constitutional structure in which you find yourself. In the case of, say, the United Kingdom, where ministers are accountable to an elected parliament, and there are many errors and many inefficiencies, some of which we've looked at this evening, that basic democratic truth remains. The judiciary must be relatively constrained, it seems to me, in the extent to which it intrudes upon decisions made by a democratically legitimate decision maker. Of course, in the United Kingdom, what we've seen here, what we've seen with the Human Rights Act, is a great increase in the power of judges, and they are, with these debates over proportionality and so forth, they are feeling how far they can go, but they still remain generally subservient to, and rightly so, to the democratically accountable organs of the state. They're not under the executive by any manner of means. The law is their only master, but they show appropriate deference. In different constitutional orders it is different. That where, for example, in particular, legislatures fail to function as they should, you frequently find that judges are able, and rightly, are able to intervene more directly in the operation of the legislature. Where you have executives that are not accountable to the elected representatives of the people or not directly elected, then there's similarly a democratic deficit. And the judges, using their own legitimacy, born of their independence and impartiality, are capable of intervening to a greater degree. Is that the answer to your question?
I think so.
Right.
Yes,
So could I ask a follow-up question? Where does Hong Kong fit in that scenario?
Well, I think that's quite an easy question to answer, Gladys. We have been talking about this at the Article 25 round table. Under Article 43 of the Basic Law, if I'm right in that. No, I think it's Article 43 that I'm referring to now. No, Article 44. I may be wrong. The Chief Executive is accountable both to the people of the Special Administrative Region and to the Chinese People's Government. And I think that means that he doesn't speak with the democratic legitimacy that might be thought appropriate in an ideal constitutional order. At the same time, this has led to, well, for many reasons, the functional constituencies being perhaps the most obvious. This has led to a bit of a logjam in LegCo. This is not ideal government. It doesn't seem to me, maybe the reason why the Hong Kong judiciary has been so bold as it has in the range of recent decisions. I'm thinking about the Social Security time limit one in particular has been so bold. But on the other hand, they weren't particularly bold in the foreign domestic laws case.
Yes, Professor. About the proportionality test, is it entirely judge-made or has any statutory base?
There have been one or two statutes passed in recent years, the details of which I did not have at my fingertips, where they have said such and such a thing has to be proportionate. But the proportionality test is essentially judge-made. The test as we have it today was in fact made by the Privy Council in a case called deference. That was the real crucial decision as far as making the test was concerned. Before then it was quite, and it's been added to since, but before then it was quite simple and straightforward, simply a proportionality between ends and means. Some people trace the origins of it back to the lex talionis of the Bible, an eye for an eye and a tooth for a tooth. This is a proportionality between the offence and the punishment, an eye for an eye and a tooth for a tooth. Others trace it back to Prussia in the 18th century. But in its modern guise, it really comes about with the European Union and the European Convention of Human Rights after the Second World War. And it's an attempt, and if you look at the European Convention on Human Rights, the word proportionality does not appear. But you have the situation where the right is set out in the first part of the article, and then the grounds on which that right may be limited are set out in the second part of the article. And clearly there's got to be some determination of whether the limitation is justified. The human rights would be worth nothing if you could say, oh yes, I know I've infringed the right, but it's done according to law, and it says here in the second part of the article that if you do it according to law, it's all right. It's the end of the story. There's got to be something more, and that something more is proportionality, and that's where it comes about in its modern guise. So it's made up by the European judges in interpreting the European Convention. When we in the United Kingdom had the Human Rights Act of 1998, again the word proportionality is not used, but our courts are bound to follow, to take appropriate account of the decisions of the European Court, and that's how proportionality comes into the
Professor Forsyth, I wanted to ask you a bit more about your critique of proportionality. And I wonder if your critique is just too sweeping. I mean, does it necessarily have to involve the balancing of apples and pears? Is it necessarily gut feeling? And I mean, I would agree with you when it depends on how you frame proportionality test. And I think in your footnote number 1, the 4th step seems to necessitate an apples and pears comparison. Same with the Canadian Oaks test at the 3rd level, deleterious effects. But I think the core of proportionality analysis is the necessity test. And I think you can frame that in more objective terms. And the Canadian courts have tended to frame it by looking at is there a less intrusive means to achieve the objective? And there you're not necessarily comparing apples and pears. You're looking at more objective criteria whereby evidence becomes controlling, and the subject matter is also very important, because then you can get into issues of the intensity of the review. Similarly with the rational connection. And again, I don't think that's just a gut feel.
No, I'm not suggesting.
Yes.
I'm not suggesting for a moment it is. It's only the weighing part where I think it's a gut feeling. And the way I presented it this evening, perhaps it was too sweeping. I would accept that. I'm not for one moment suggesting that proportionality is going to disappear or that it should disappear. And I think we have it, and we're going to have to live with it as for some time to come. I'm not suggesting that for a moment. And I would agree that not every case involves the weighing of apples and pears. Not every case involves the apples and pears. But I think a significant number of proportionality cases do. The kind of case that you suggest is when you are answering the 3rd question, you've got an infringement of the right, and you're now looking not at other rights that may be weighed against it, but essentially utilitarian considerations that may justify the limitation. That, it seems to me, is the closest you get to a non-apples and pears situation. But that there are many proportionality cases in which it is an apples and pears situation, and where it does in effect come down to judicial instinct.
I mean, just sort of quickly reply to that. I mean, another perspective is perhaps it's just bad legal reasoning. Perhaps the way the judge or the appellate court has framed it in terms of an apples and pears weighing exercise is really not the proper way of thinking about the legal problem, and that it's just not the right approach.
Well, what would the alternative be? I mean, clearly you've got to deal with the cases as chance presents them to you. And if you've got a case like Quila, do you think the analysis in Quila, how would you analyze Quila so it wasn't apples and pears? I mean, I think one of the things you could say, if you wanted to justify Quila can be justified on the basis that the evidence was so poor that one fails to make the rational connection test. And there's clearly some mileage in that. But that leads on to another point that I'd like to make, which is really about the nature of government decisions. You know, judicial decisions look back. They're based on evidence. They assess things that have happened in the past. Governmental decisions very often are based on imperfect evidence and making assessments about other people, how they're going to behave in the future. And that is what is happening in the Quila case. The Home Secretary has to make a judgment on the basis of imperfect evidence about forced marriages, because you can't go and the evidence is not readily available as how widespread this problem is, although we know it is. You've got to make it on imperfect judgment, imperfect evidence, and you're making a judgment about how other people are going to respond in the future to the change in the rule. Those are not judicial tasks. Those strike me as being governmental tasks.
We have time for one very short question.
Yet Ambrose has been offering a question.
Professor, I don't profess to know everything about people, but it seems that only a cursory review of the case, it's disproportionate to say, well, you can't make the application before 21. One would have thought the Home Office could easily say, well, you could make an application between the age of 18 and 21, but we will subject you to a vigorous investigation or scrutiny. And it cries out to me that the proportion is disproportionate to simply raise the age limit to 21.
Well, that's what the majority thought. I mean, what you propose is to substitute a clear rule. You've got to be at this age to make the application, with a further discretionary approach in which there's been inquiry and a decision made and so forth. Many more applications for judicial review, etc., which is, of course, good for the bar. But in the end, we have to have, at some level, we've got to have rules for things.
But what we have seen in Hong Kong is that a lot of the judicial review is necessitated because the administration just wants to have blanket rules and no discretion. And so time and again, you come up with extreme position, which on the face of it is disproportionate. It's simply because of administrative convenience. Nobody wants to exercise discretion, and no one wants to deal with things on a case-by-case basis. And if you're right, then the courts should lean in favor of lazy administrators who simply say, well, we want clear rules and we don't want to exercise the discretion.
I'm not saying anything like that, really. I mean, there are many grounds of judicial review that the decision maker must act within power, that they must act fairly, that they must take into account relevant considerations and not take into account irrelevant considerations, that they must act for proper purposes and not improper purposes. We're only talking about, and particularly an important part, whether there's anything beyond that, namely substantive review. Do we have a test of whether they must act reasonably in the Wednesbury sense, or whether we have a test that they must act proportionately in the sense of the structure test. I mean, that's what the debate is about, not the end of judicial review.
Not the end of judicial review, but I'm afraid that's all we have time for tonight. Please join me in thanking Professor.
Right.
Done already. Yeah, I finished my Viva. Fingers crossed, actually.
Yes, see that very
So have you got anything
supposedly have
written down? Yes.
但係咧佢係嘛？ Yeah, okay. You remember this is Stephen Ronnie has a son, and that's it. Albert one we wanted to Alberto's project.
Oh, right.
You remember he was with
She was so
in the morning?
absolutely correct to say that unlike his father. He was so
No, I
clever.
said, this is, wow, I said, he's a clever man, I wouldn't believe it.
Yeah, you see, effectively, well, this is what she said. Unlike his father, he's so clever. Right, we get on to your eyes there.
Oh, you have to rush? Okay, see you anyway.
Good to see you. I'm Wednesbury.
Sometimes.
As far as granting holding the government to its promise, or just a procedural remedy.
That's a different topic that I wasn't addressing in this lecture. But on the whole, I think substantive
It just
review
happens
and
that
substantive protection and substantive review is quite an exception. And it effectively comes about where there's effectively comes about where there's a private law or contractual relationship.
We should be
That was the
asking
case
about
of
a lot,
Cochran.
at least they're more robust than
Okay.
Campbell.
That's the
But then
sort
you
of
just never know
archetypal
what you're gonna
situation where legitimate expectation can be substantially protected.
Okay.
Small people a very specific
Welcome.
promise.
You celebrate your conglomerate, I celebrate GA.
It's all good project.
So we win some, you win some.
These are Andrew's
Yeah,
ropes.
that's what I was coming to.
Yes, right.
A formal answer to it is that it applies after. It applies afterwards, once you've gone through the line of judicial, part of when you say that this is within the margin of appropriation.
You can write it, that's my list of things to do tonight.
My colleague, Professor Trevor Allen, argues to the contrary.
Avoid laundry.
That
Yes.
must be taken into account.
I wasn't serious at the time.
Never again.
Apparently I'm the only one that's criticizing conglomerate. Everybody's celebrating.
You need to have people like you around.
Even Albert is a bit sanguine about it. Oh, you read it?
He was, no, he was telling us.
The CFA book. CFA book.
But you have another book.
I have another one.
I'll send it to you tonight.
We had a book.
Just to see whether a right is fundamental, and if so, they accord any margin of appreciation.
No. Oh, yeah.
Accord margin of appreciation. Then at
No,
the
he
stage,
mentioned that,
they
he was more disturbed by the fact that you
that
already
I
had
think
your
it is absolutely
commentary
right to
ready
say
before
that
he
some
was
rights
reading
were
the decision.
He said it to
everything.
He sent his draft to me, and I said,
I'm
Albert,
not quite
I
sure
have
what would be
no
by fundamental.
comment, I had nothing to dispute with on the case, other than I thought that it's quite objectionable. He said it was
think
stroke of
they
genius.
send them to the cleaners.
the whole outfit, right?
Well, I was like, how is that?
And you can see how they had that.
Yeah, no, I said it's a moment of folly.
Your article
No, I like this title.
And I could write on GA.
That's what I said. Didn't I say that in the lecture? If it were free
There's so many pending projects
Gus?
that I need to get out the pipeline before this gets out the pipeline.
So I was so
Always there in badly long,
Yeah.
long, mà你睇嗰個
Badly, yes.
tag係啦，真係。
Yeah.
So you're teaching?
Yeah, comparative convo. Well, I hope to catch up with you sometime this week. Would you want me to email you tonight?
Yes.
And you can.
email me and I'll respond to that.
Okay.
I'm out lecturing for 3 hours tomorrow morning, but I'll try and respond before I go out.
You really don't give yourself a break, do you? You really not let up since you arrived.
All right, then I'll catch up with you sometime this week.
Hope you enjoyed that.
When you compare the size of it seems
As she told me not to come and see, she told me it's very difficult. No, I'll engineer really enjoy it. Thank you so much.
So I'm glad you enjoyed it.
I do, yeah. We think engineers think so difficult. Only got black and white now.
Someone's going to take you back to.
Yes, yes.
Okay.
Thank you. How are you? Nice to see you.
Yes.
Very distinguished audience.
Oh, no. Send me an email.
Set the impression that, well,
Can you come to
if
the meeting
government
on the
is
20th?
diligent in the sense of enough evidence to put in court, then
Yes.
there's a greater chance that
Unison,
God will work it
let's
out.
go.
Yes, yes, I think that is it.
I just haven't seen my diary, but yes, I'm done. I'm done.
The more opportunities to find errors.
That's what the judge over the shoulder teaches.
Teaches the government to how to avoid errors.
Thank you, Raymond.
You must be quite worn out.
I'm quite worn out.
Yeah, the whole day, so no need to talk to us at all.